Okay, we'll hear the next case. I neglected to say at the start that we'll probably take a break after the second case. The next case is coming up. So we'll take a break between the second and third case. Okay, we'll hear argument now in 22-2351, RBD Investment Trust et al. Versus Babcock QMI and Jeffrey Wells. Counsel.
Good morning, Your Honors. May I please the court, Robin Hazel here on behalf of the appellants. I would like to reserve 5 minutes for rebuttal.
Thank you.
So, Your Honor, we're here today because we're asking this court to reverse the trial court's order denying our motion for a new trial because on the issue of the appellee's tortious interference with the contract. The jury's finding, specifically that finding that the appellants breached the agreement to assign the original contract in this case to Babcock and therefore forfeited their rights under that original contract, is clearly, obviously, and indisputably wrong. As a result of that, it's against the manifest weight of the evidence and the court's judgment should be reversed on that issue. Here we have a
Counsel, what you're telling us is you can't reconcile that there was no contract with the tortious interference finding by the jury. Isn't that really what you're telling us today?
I would state it a little differently, Your Honor. It's not that we cannot reconcile the finding of a forfeiture, because if there is no contract, then we couldn't forfeit any rights. That the non-existence could not cause us to forfeit rights under a different contract. The appellee's argument is essentially that because there was no assignment, there was a promise to assign, the jury found very specifically that there was no contract between Wells, Babcock, and my clients. So if there was no contract between them, then they could not forfeit any rights to a contract that Mr. Wells wasn't a party to because they didn't assign rights under a contract that didn't exist.
That sounds to me, counsel, like an inconsistency. Why is that not an inconsistency that should have been brought up in real time to this judge saying we have an inconsistent verdict form?
Because in this case, Your Honor, I think it goes beyond just a mere inconsistency. An inconsistency means that two things can't exist at the same time. While it's true that that's what it is here, you can't forfeit a contract that didn't exist, it goes beyond that because when an issue is against the manifest weight of the evidence, that's where there is no evidence to support the claim. There is no evidence of forfeiture in this case. Not only that, there is no evidence that even the original oral agreements between the parties, the original discussions they had to form a formal agreement, there was no discussion of forfeiture if that act was not performed. So it's not just that there's an inconsistency. Here we have a case where there is just no evidence to support the finding of the jury that there was forfeiture.
Well, you're saying, counsel, and I know you know words matter, it's not just an inconsistency. Are you telling us there is an inconsistency plus here?
I can see it. I can understand why it would appear to be an inconsistency because there is no contract, therefore there's no forfeiture. But the case law that defines what against the manifest weight of the evidence says, it says it has to be something that's clearly, obviously, and indisputably wrong. In this case, the forfeiture is indisputably wrong because there is no agreement stating that if there wasn't a performance of the original assignment, that there would be a forfeiture. So that's a clause that the jury found that existed in a contract that they also found didn't exist. So it's not quite an inconsistency plus, although I can see how Your Honor would look at it that way, and it wouldn't be incorrect to look at it that way, but I think against the manifest weight of the evidence goes a step further than just a mere inconsistency. Because
if in fact it is an inconsistency plus, is that not something that would need to be raised to the trial court before the jury is excused?
In this case, Your Honor, I think because where the case law sits on what is considered against the manifest weight of the evidence, I would argue that in this case, we did not have to raise it to the jury because it's so clearly wrong on its face when you look at the record, when you look at the fact that there's no evidence to support it. So a traditional inconsistent verdict, there can be arguments on both sides, and the jury just made a finding where the two just can't coexist. In this case, the two findings of the jury, there's just absolutely no evidence to support one. So that's why we're at against the manifest weight of the evidence, not just a mere inconsistency. And so in this case, we would submit to this court that the jury's finding that there was a forfeiture of when it already found that there was no contract, there was no agreement, there is no obligation, there were no fraudulent statements. The jury made all of those findings. To then find that there was a forfeiture where there is no contract is where we say it's against the manifest weight of the evidence, not just an inconsistency. And it's interesting that the appellants in this case, they agree that there is no contract because the underlying contract to assign the original contract with the Jenkins to Babcock, if there was a contract, then my clients would be part owners of the sand mine. The appellees are very firm in their argument that we do not own any portion of the sand mine. So therefore, there is no contract and there could be no forfeiture of any rights because of a contract that did not exist. And there's nothing in the language of the original contract between my clients and the Jenkins that says that they can forfeit their rights under that contract. The fact that my clients did not come to an agreement with Mr. Wells did not give him carte blanche to tortiously interfere with the original contract between my clients and the Jenkins, which is what he did. The jury found that he did this. The jury found that there was interference and that it was intentional and that there was no excuse for it. The forfeiture argument, the forfeiture finding of the jury just is not supported anywhere in the evidence. So unless Your Honor have any other questions, I'll reserve the rest of my time for rebuttal.
Good morning, Your Honors. May it please the Court. My name is Howard Poznansky, and I represent the appellees in this case, Babcock Coquina Mine and Jeffrey W. Wells. I just want to backtrack a little bit in terms of the factual scenario here, because when we take a look at the appellant's brief, particularly paragraphs 23 and 24, we see in the brief that at trial, Mr. Davis and Mr. Wolfington testified that no binding operating agreement was entered into. So we have sort of an after effect whether or not the binding agreement, operating agreement was entered into. When we take a look at the trial testimony and we talk about inconsistencies, what we see in the record, and this was on record page 288, 99, lines 11 through 20, where counsel for Mr. Wolfington, Mr. Davis, and their entities questioned. So when we go down to count 1 of the complaint where it says a breach of oral contract, if I tell you this complaint, the oral contract being described as the November 17th agreement, is that consistent with your memory? The answer is yes. Okay, but was that oral contract between you and Doc Pancratz and Dr. Wolfington and Jeff Wells, or with some other entity? With Jeff Wells. The evidence, the manifest weight of the evidence clearly reflects on November 17th, there was an agreement entered between the parties as it relates to the assignment of the contract to Babcock Coquina Mine. So we have that fact that there was an assignment that just never happened. Maybe the parties subsequently had issues with the operating agreement, but as it relates to that November 17th meeting between the parties, it's clearly reflected in the evidence that an agreement was entered into. So when we take a look at the facts of the particular case, the manifest weight of the evidence, and we look at what the jury is capable of inferring, yes, the jury is capable of inferring, even before we get to the issue of whether or not there was an inconsistency, we are able to, the juror was able to infer specifically that.
Are you arguing that there was no inconsistency here?
What I'm saying, first and foremost, before we get to that point, the jury correctly decided the case. Now, to the point where if there was an issue as it relates to the verdict, yes, there would be an inconsistency in terms of there is an agreement and there is no agreement. It's a black and white issue in terms of no matter how we want to frame it. So what I'm saying, level one, the jury got it right. Level two, if the court is going to sit there and say, well, maybe there was an issue that related to the actual verdict, that would have been an inconsistency that would have required counsel for the appellants to stand, object, and make the argument so the jury could then go back to the deliberations and rectify if in fact there was an inconsistency.
Well, and I'm curious about that because how would they rectify this? I mean, let's just think it through. Let's say there was an objection raised, Your Honor, we have an inconsistent verdict here. This part of the verdict form is inconsistent with the later part of the verdict form. What do you tell that jury to go do? I just want to think this out. What would you describe to that jury that they needed to correct?
There would have been a curative instruction that would have been provided where the court would have indicated that there was an objection raised, that there's an inconsistency because the verdict would have already been rendered by the jury in terms of what it was. The objection would have been raised, and then we take a look at what the specific jury verdict reflects, and then it's easy to say to a jury, to the jurors in this particular case, on one hand, you're saying there is no contract. On the other hand, you're saying there isn't a contract. We want you to go back and deliberate. Now, keep in mind, at that juncture, the jury can go back and look through the entire instruction again, the entire verdict form, I should say, and make a determination in terms of the verdict form that may not have been the result that they wanted. It should have been to check another box as opposed to that box. So it's easy to give a curative instruction for the jury to go back and say, there's an inconsistency. Is this the verdict that you wanted? And if not, go back, reevaluate the entirety of the tortious interference jury verdict, and go back and come back with another decision. So certainly a curative instruction could have been provided, but in this case, they never had the opportunity. So with respect to what a jury should do.
So again, just trying to think it through. You said that, and it didn't happen here, you send them back, you tell them there's an inconsistency, they continue their deliberations. Suppose they come back and say, we stand by our determination. What happens then?
In that particular case, we end up before the 5th DCA, again, as it relates to that particular verdict and making that evaluation on those particular facts. But we also need to understand, as it relates to this particular...
Does the judge get involved at that point? I mean, I understand you discharge the jury, you can't continue to force the jury to go beyond what they've done, but does the judge get involved in that point and then evaluate that issue, this inconsistency at that point, and perhaps order a new trial?
That would be the appropriate procedure at that juncture, in addition to the objection. If the jury comes back and stands on it, and the trial court determines that there's still a particular issue, there would be either a request for a mistrial on the point, a motion for a new trial on the point, and we would end up back before the court. And again, as it relates to this particular issue, there's the other subcategory of the record in terms of damages. So while we have the appellants coming before the court here today and saying we want an entirely new trial on the issue of tortious interference, we're still looking at the fact that even if there was, which I submit to the court, there wasn't an issue that would bring us before the court, there's still the issue of the damages. Even if the jury would have went back and reconsidered and they would have said, hypothetically, there is an inconsistency, let's check the box, then they need to evaluate the issue of the damages. So when we take a look at the appellant's motion for new trial that was submitted to the court, there were two issues. There was one issue as it relates to the verdict, but there was also an issue in the appellee's response to the trial court that says, even if there's an issue of the verdict, which of course we don't suggest that there was, but to the extent that there was, there's still a lack of record damages that would have sustained a jury verdict to begin with. And that's an issue that was raised in the brief as well, to assert that if the court, in its opinion, says there was an issue and this should get reversed, there's still an issue out there that needed to be resolved and wasn't. And that was the issue of damages, and that was a motion that was raised in terms of the appellee's response that, Your Honor, we believe it's an inconsistency. To the extent that the court wants to say yes or no, there's also another issue during the course of the trial, which we don't see on the record because it wasn't provided to the court. There's still that issue of, even if the court says, okay, I want to grant a new trial, there was still, during the course of the appellee's case in chief of trial, the motion for directed verdict on the issue of damages. So when we take a look at the record, even if there is some semblance of an issue as it relates to the particular inconsistency, there's still the issue that the court easily denied the motion for new trial because there were no damages proven at the time of trial that would have provided for recovery to the appellants in this particular case.
Counsel, if the inconsistent verdict issue has not been preserved, and we're left with the manifest way of the evidence already on appeal here. And I understand that the appellate standard for motions for new trials is discretion. How does the manifest way of the evidence standard apply? In other words, what are we as appellate judges to do when we get this type of claim where they say there's no evidence to support this whatsoever? It's against the manifest way of the evidence. The jury usually basically act as a seventh juror and rule for us.
Well, when we take a look at what the standard of review is, certainly the trial court has discretion on that point. And when we take a look at the overwhelming evidence that was submitted to the trial, to the jury in this particular case, that was also heard by the trial court, I don't submit to the court that there is manifest, the weight of the manifest, the manifest weight of the evidence supports what the appellants are asserting in this case, because there's equal evidence on record here that the court looking at, is it clear? Is it obvious? No, it's not clear. It's not obvious in terms of being able to sit here and suggest that there's absolutely no evidence. There is record evidence, and that's even in the form of the own testimony of the appellants during the trial as to what they said occurred on November 17th, that an agreement was entered into. So in deference to the jury and the court not sitting there and saying, I'm going to be that particular additional juror, which the court would certainly, in certain circumstances, be able to make that determination. In this particular case, the trial court wouldn't be that extra juror to make the decision. There's certainly sufficient evidence that supports what the jurors did in this particular case that would allow for the jury verdict to stand. And for the trial court to have sit there and denied the motion for new trial on that particular basis. If the court has no further questions, thank you, Your Honors.
Counsel mentioned that the jury correctly decided the case, and if that were true, then it would equally be true that the jury found that there was no contract between Mr. Wells and our clients. Therefore, there could be no forfeiture because of a failure to act under a contract that the jury found did not exist.
Go ahead. No, sir. Go ahead.
Please.
Is that not quintessentially an inconsistent verdict? I know you're arguing, I'm tracking it.
Yes.
You're arguing manifest weight of the evidence. But that which you just presented, is that not the textbook definition of an inconsistent?
I would argue, Your Honor, that what we have here, goes beyond just a mere inconsistency, and I'll explain why. One of the things counsel mentioned is that there's plenty of evidence on both sides. We disagree with that. As to the issue of forfeiture, there is no testimony in the record that a consequence of failure to assign, if we were to even assume that that contract existed, there is absolutely no testimony that a penalty for not completing the assignment of the contract between Wells and my client, not assigning the Jenkins contract to Babcock and Mr. Wells, that the penalty for failure to do so is forfeiture of the original separate contract with Jenkins. There is nothing in the record to support that finding. And that's why we say this goes beyond just a mere inconsistency. There is absolutely nothing in the record to show that forfeiture was a decided penalty, that the parties got together and said, if you don't assign your Jenkins contract to Babcock, then you forfeit your rights under the Jenkins contract. There is no testimony about that. So the jury's finding that there was a forfeiture based on the parties' agreement, they originally found that there is no agreement. But even if we were to assume that there is no evidence in the record to support a forfeiture clause. And that's why we say that the issue here is that it's not just inconsistency, but it goes beyond an inconsistency. It's against the manifest weight of the evidence because there is no evidence to support a finding that forfeiture exists. There was no forfeiture discussed among the parties, and therefore there was no forfeiture that happened in this case. And if the court does not have any other questions, then we rest on our brief and the arguments presented.
Thank you. Thank you both for your arguments. The next case we got scheduled at 10 a.m., so we will